Good afternoon. Thanks for joining Ask an Expert. Today, we're very excited to have Nate from DRI, Disability Rights Iowa, and Len from University of Iowa Law School. They're going to help unpack restraint and seclusion. Next week, they are going to join us again about therapeutic classrooms. So please get on the Ask website and sign up for that. Also, we have some documents on our website around Chapter 103. Actually, Len and Nate helped us, gave us feedback this summer. And I even just got a kudos from Nate that said that they're good. And so they're family friendly is what we tried to really do and help unpack seclusion, restraint, a checklist, those types of things. So just please go to our website and you will find that information there. So that being said, gentlemen, I'm going to turn it over to you.
Like Deb said, my name is Nate Kirstein. I am an attorney at Disability Rights Iowa. Part of my caseload over the time that I've been here since 2012 has been special education cases. So I've dealt with a lot of restraint seclusion type cases representing parents and students in those issues for some time now. Len?
Hi, good afternoon, everyone. I'm Len. I'm also known as the free lawyer, and I've been partnering with Nate and Mary Richard and DRI and many other lawyers for a few years now with many parents and teachers and instructors in how to overhaul the system that was in place for decades and led to sort of the disproportionate use and abuse of seclusion and restraints in schools. And I know many of you listening in have personal experiences with yourselves or your children or your students. And that always informs us as well. This is sort of the new and improved, but not the best set of rules that we could come up with because it was a consensus document. And consensus usually means that there are deals made in barter and you never get quite what you want, but the Department of Education really played a leading role. So I thank them as well. This is going to be family friendly, and we're going to try to make sure that we talk with you and then receive your questions at a level that we can assist you, because that's what we're there for. But we're also always available, and you know that, by email or other. So I'll just turn it back to Nate. We'll talk about first the history of the rulemaking very briefly, and then what's changed. And then we'll talk about places you can go and things you can read that will assist you and arm you with the information you're going to need to navigate children through the system in a way that they receive the safest quality education possible.
So just some brief history. As Len mentioned, myself, him, Mary Richards, a couple other attorneys that represent parents and students across the state, as well as the ACLU of Iowa, petitioned the Department of Education for rulemaking back in 2017. And so basically what that is we said, look, Iowa Department of Education, you haven't changed your rules on restraint and seclusion in schools since 2008. A lot has happened since then. A lot of research has come out about the harm that restraint and seclusion can cause to youth in our schools, as well as ways of avoiding the use of restraint and seclusion and other types of interventions that are positive behavioral interventions. So at that time, the Department of Ed entered into a rulemaking process. And like Len said, invited several stakeholders to the table, as well as us petitioners. And then we had to hash out these new rules. What would be in them? How would they look? What type of language would be in them? And so on and so forth. And ultimately, we got to places where, like Len said, not everything that we wanted as petitioners got placed in the rules or got taken out of the rules. But we did get somewhere better than where we were at before. And ultimately, these rules became effective as law in January 20th, 2021.
A lot went into this, especially comparing the regulations and laws of 50 states and how we measure up and how we didn't measure up in different fields. And for people who are interested, there's an article online. It's How Safe is the Schoolhouse? And it's a 50-state comparison. So if you're interested in even improving on the rules and changing them in the future, That's a really good source, and they're updated fairly often. Administrative code really was a ban on corporal punishment. And the idea was to immunize and make teachers and schools immune from civil suits or criminal suits in the event they crossed the line and went from behavioral safeguards to physical contact for the sole purpose of punishing people. And that was the core. It'll just now go through what changed and why it's important to us.
Exactly. What Len was saying there in terms of, there's stuff that the legislature does and that becomes law, right, or code. And then the legislature can say, hey, we're giving you a certain amount. And then Department of Education or Department of Human Services, you all as departments, you figure out how to detail this out in rulemaking. And just so you all understand, we in Iowa do not have something that's been made by the legislature that says anything about restraint or seclusion. And that's what Len was speaking about. We have something that the legislature put together that's law, that's about corporal punishment. And so that does have a physical aspect to it, right? And so that's the statute, as Len said, that's the law that the Department of Ed is using as their authority to even make these rules about restraint and seclusion. And so there are certain things that the department can't go out of that span of what they're authorized to make rules about. And so there's certain things in these regulations as we share them that they just have to have in there because they're in what the legislature made up as the corporal punishment rule. Okay. So what changed? Number one of the biggest things that changed is just readability and clarity within these rules. So they're easier to understand. They're organized in a way that's very intuitive. And there's actually an actual section of definitions that defines what seclusion is, that defines what physical restraint is, that defines what debriefing is. And we'll talk about that in a minute. Also, there's stricter criteria for when a school staff member can enter into using a physical restraint or the use of seclusion. And that actual criteria now is to prevent or terminate an imminent threat of bodily injury to the student or others. That is very different from what those rules said before. It's very clear that this is to prevent or terminate an imminent threat of bodily injury to the student or others. Also, it can be used to prevent serious damage to property of significant monetary value or significant non-monetary value or importance. So the property piece, that's in that part that's in what the legislature decided you could use physical force for, right? So we petitioners tried to get the property piece taken out of the rules. Department of Ed said, no, we can't do that because the legislature has them in the statutes. So that property piece is in the rules. However, we wanted to make sure, look, we can't use physical restraint or seclusion for someone ripping up their math work. This has to be about something that's of significant monetary value or significant non-monetary value, like if they had the painting of the Mona Lisa up in their classroom. I'm sure we don't have that in Iowa, but that would be what significant non-monetary value looks like. All right. So restraint or seclusion can be used to prevent serious damage to property of significant monetary value or significant non-monetary value, right? Also, it can be used when the student's actions seriously disrupt the learning environment or when physical restraint or seclusion is necessary to ensure the safety of the student or others, and when less restrictive alternatives to these things have been proved not effective, right? Essentially, this has to be done in what would be considered more emergency-like situations, okay? That's a way to think about this. It should be last resort. It shouldn't be used for when a student is not listening to the teacher and tapping on the desk. It shouldn't be used for when a student refuses to do their work right then. It shouldn't be used when they rip up a piece of paper or break a pencil or pen. Those are not the things it should be used for, okay? What else did we change? We got some stricter time limitations. And before, there wasn't necessarily as strict time limitations. Now, if there's anything that lasts over 15 minutes, they have to get approval from an administrator. And there's stuff in there that says what that approval has to look like in terms of how that approval happens. There's a few added trainings. The regs before had several different trainings that staff had to be involved in. Additional trainings were added to that list to make sure that we're arming our school staff with everything that they need in order to avoid the use of restraint and seclusion and de-escalate properly before you even get to that point. Also, what was added was a debriefing section that talks about all what needs to be happen if restraint or seclusion happens. Then afterwards, when debriefing has to occur, what has to happen during that debriefing meeting, and what documentation has to be included with after that meeting so that the school is documenting exactly what happened. The details are all within the regulations, and a link to the regulations is included in the chat box right now. So you can click on that link and look at these details. Essentially, without going through every single detail, debriefing has to occur after the first use of restraint or seclusion in the school year, or after 7 instances of seclusion or restraint in the school year, when any personal injury occurs, either to the staff or the student, whenever a reasonable educator would decide it's necessary to do a debriefing, and whenever it's suggested by an IEP team, or whenever the parent agrees with school officials to have a debriefing meeting. So basically what that means is it can be held quite often, debriefing meetings, if there is restraint or seclusion happening often. What's the sole point of this meeting? To understand what happened before, what happened during the restraint, and what happened after, and then understand how are we going to avoid this in the future? What are things that we can do to avoid using restraint or seclusion in the future? And that should include the staff talking about what they can do, not just what the student can do, because that's not an appropriate debriefing meeting according to these regs. It includes what staff can do differently as well.
One of the things is the 3 points seem to be, just to piggyback on Nathan, one, the training shifted considerably. That was one of the biggest complaints, that there were special education instructors who had special modules and training in different districts, but the teachers who were not in special ed weren't given the training other than looking at PowerPoint. So the idea was to make this training much more interactive, on site, but at least by video and other instruction, with accountability being that people would have to actually take tests to show that they understood the materials. But one of the prophylactic measures is, for the first time, the teachers were schooled rigorously more in how the preventative practices, all the steps and strategies they can use to reduce or eliminate the need to lay hands on a student or guide them into a room that's isolated, and those rare instances. And also to remind everybody that this has to be based on scientific best practices that are being developed around the country. And most recently, when I went on the DOE website, the Iowa Department of Education website, they were also putting out bids for social, emotional, behavioral health guidance, that they were going to contract with someone to perform this and to create a curriculum and to create an entire system that will educate teachers and also be statewide rather than just particular to a district. And we were hoping that there would be much more on-site training. The students and administrators, and maybe with students, would be walking through scenarios where I would be acting out, which I did as a kid. I saw the principal's office many more times when I attended school than I wanted to. But the teachers rightfully are fearful that they're not equipped to do this. So the option was, let's call in the police or the school resource officers. And that usually led the kids down the pipeline into juvenile court or something else. So now the state's placing great emphasis on that. The other thing is accountability for the instructors in the school, in the sense, as Nate said, that for the first time, they have to create report, a narrative report about what happened, keyed to what they were supposed to do under the law. And we'll talk about this soon, but what behaviors led to it, what they tried that didn't work, or why it couldn't work, who was involved, and the particulars about the timing, how long it was, what they actually did, and if they got permission to extend the seclusion, because there are times when they need principal or an administrator's approval to keep it beyond 15 minutes. So everything was done to limit the use, and there was not going to be a way that the department would eliminate the use of seclusion rooms or physical restraints. That battle had long been passed by or lost, because there are times when there are certain behaviors by students who require that. It's just that now the parameters are much tighter and narrower, and teachers now have a sense of when they should intervene and when not, and what they should be able to do, because they are really in a tough predicament as well. But usually without the reporting and conveying that information to the parent in writing, and then inviting them to a meeting where they can participate and exchange ideas. What happened? What are you doing differently? And also to tie it with special education, because I know Nathan will talk about that pretty soon, about the relationship between kids who have an IEP or behavioral plan, and the difference between what happens with them and kids who do not have special education plans as well. And the last thing, I think, is the room itself. And that's one thing as parents and people involved you can check, is that by 2025, the rooms have to comply in all respects with size, heating, ventilation, locking, all the specifics that we borrowed from other states to make sure that the rooms are not going to harm the child, and that they have adequate ventilation, lighting, and more important, that the teachers can monitor what's going on, even though there's no requirement that they keep an eye on the student every minute of the time they're in a seclusion room. And wait, hot updates are hot off the presses. The Department of Justice attorneys have contacted us and many other people to let you know that they are investigating the use of seclusion and restraints in the Cedar Rapids Community School District. So if you have not yet done so, you can contact me, you can contact Nathan or Mary Richard, and we'll put you in touch with U.S. Department of Justice trial attorneys who are looking for information.
Thanks, Len. So just to touch on a few things in terms of reporting. The regs before did have a requirement for documentation of each use of restraint and seclusion. These regs now make it even more clear what needs to be in that document. And so what needs to be in that document are things like, when did it occur, the dates, the time that it started, the time that it ended, who was involved in terms of all the staff that were present. If it went longer than 15 minutes, who was the administrator? If you couldn't get an administrator, you got to explain all the reasons why you couldn't get an administrator's approval to go over the time of 15 minutes. Also, what has to be included in that report is what happened before, like what was the behaviors that led up to it, what happened during the restraint or seclusion, and what happened after. Those are the major things that need to be in that report, and that report has to be provided to the parent within 3 school days of the incident that occurred. The parent can agree to accept this electronically through email, things like that, or it can be sent through U.S. Postal Service. So that has to happen. Also, within that document has to be a documentation of how they tried to get a hold of the parent shortly after the seclusion or restraint occurred. And per the regs, the school has to try to get in contact with the parent at least by the end of that school day that incident occurred, through phone, text, whatever the parent and school have agreed upon as emergency contact for that parent. That's how they're supposed to do it. And then that has to be in that document that they send to the parent within 3 school days of the incident that occurred. Also, an additional document that wasn't included in the previous regs is that documentation that I was mentioning before of the debriefing meeting and all that occurred in that meeting. And that includes what's the plan in the future for avoiding the use of restraint or seclusion. How this ties into students on IEPs is that part of that debriefing process. If this student's on an IEP, there should be some decision made about, hey, do we need to have an IEP team meeting? Because if we're having several restraints or seclusions, or one intense one, let's say, maybe we need to meet as an IEP team and decide whether we have the appropriate supports and services for this student moving forward. Maybe we need to revise the behavior intervention plan. Maybe they don't have one yet. Maybe they need one. Maybe we got to do a functional behavior assessment to understand what the functions are of the behavior. So there's lots of things that should be the folks meeting for the debriefing should be thinking about in terms of having a possible other meeting, an IEP team meeting, to make decisions about the appropriate supports and services that are needed for that student so that we can avoid the use of restraint and seclusion moving forward. And that none of that stuff was clear in the previous regs. Now it's very clear, and like Len said, it's got to be documented. What's also additional in the regs is a reporting requirement to the Department of Education in terms of reporting each restraint and seclusion. The school districts have a duty now to report each restraint and seclusion to the Iowa Department of Education. And then lastly, I'll just mention, as Len stated, there's a whole lot more criteria about what a seclusion room looks like, what it has to be like, how it has to be constructed. And one of those requirements is that it's got to meet basically all the building codes. So that's fire, that's public health, has to meet those, right? And they have to have an inspector come out and look at them. And that inspector has to provide them something in writing, and that document has to be kept by the school. And if they have documentation of the room meeting several of the requirements, most of the requirements, then the minimum dimensions, which right now has to be at least 56 square feet, then they can hold off on making the change in dimensions, basically building a new room if they don't meet that until 2025. Otherwise, everything else is supposed to be met by July 1st of 2021. So right now, as it stands, everything except for the size requirement, including the building inspectors looking at this stuff and having written documentation that they've looked about, all that has to be done now. The only thing that can wait till 2025 is the minimum dimensions.
And that will probably temper the school district's insistence on building new seclusion rooms. One, because it's an investment that doesn't have a payoff for them. Two, that if they have to follow all the rules, they could probably build a different schoolroom that would have benefit more students. But making sure that they were inspected for the first time was critical. The other thing that you may want to do is ask your districts. There's no requirement that the school districts or the schools make public the reports that they send to the Iowa Department of Education. In fact, we know that at least one district has refused a public records request to do that. So I would suggest you just ask your schools. One, for the forms they use, as well. Two, for any policies which they're supposed to post on their websites and give to parents each year. Usually it might be in the student conduct code. And so a lot of times you just Google seclusion or restraint or incident report, and you'll find out a lot of the information. And
Len, do you want to talk about real quick the training and guidance materials, things that you've looked at?
sure, yeah, I went on a scavenger hunt because I love scavenger hunts. And I went on the web and I said, okay, let me find out what's going on. And here are my sort of top, I don't have a top 10, but these are the top 10 things you might refer to as well. The simple one, and I think Ask has it on their webpage, is the Department of Education guidance, the top 10 points about Chapter 103. It's easy to read. It blocks out everything we've talked about in order, and it refers to the regulations. If you're in the mood for a popcorn night and you have access to streaming, the video training is available online. You can show it to parents and groups, and it's done by the Alders and Cooney Law Firm that represent the school districts. And they did a really nice job on this, discussing what the requirements are, but it's keyed to what I call number 3. But you have to really be interested in devoting a lot of time, because it's the statewide training manual. And it's online and we can send it to you. It wasn't publicly available. It's the AEA training. And it's called Overview of State Requirements and the 2021 revisions. And it has quizzes as well that have to answer. But the beauty of this document is not only does it go through definition, the do's and don'ts, but how are you supposed to use your discretion as a teacher? It emphasizes it's a last resort. Even though we couldn't get those words into the rules, everybody knows it is. And they talk about what to do when behavior is unacceptable, all the alternatives and disciplinary options like redirections, offering choices, time out at desks, time out at classrooms, and anything short of a room clear. And I think as a parent or a teacher, this is really excellent. If you saw the movie Patton, Patton defeats Rommel's troops, and he said he read his book overnight. Damn it, Rommel, I beat you. I read your book. And this is what you have to know. This is the Department of Education saying, here's what you do. And they tell you the different phases of crisis intervention and when there's acting out behaviors and about the strategies to use. And then the last thing, and this is what I found valuable that I really hadn't seen in one place, it's the positive behavior and supports from the Office of Special Education Programming. And it talks about how the policies are supposed to work with the data gathering to change the practices and change the outcomes. That's number 3, but you've got to have a lot of time to read it. Number 4, if you want to know what all these forms mean, the best incident report is from the Linn-Mar School District. And we'll have this available to you, but it's policy documentation and it's keyed to the rules, but you can fill it out by hand. So it allows the teachers to fill it out. And if you download it, you'll know what questions to ask and what rights you have as a parent or a teacher when you are going through the documentation. Ask Resources Chapter 103 checklist, great companion piece about incidents and debriefing. The next thing is Linn-Mar School District has a debriefing chart as well. But if you're interested in the data that the school district collects, it's the Centerville Abington. I never was familiar with that, but they have a form and it checks everything about environment, place, who was involved. And also the Perry School District has a letter to the parents that says, we've had an incident, we're writing to you as a parent after the incident, and we're inviting you to a debriefing meetings. And there are other materials, but these seem to be the best. And that's what I would do, is to look at those and bring them to the meeting with you, not just the forms that the school provides you, but to look at other examples. Because I find the ones that give space that you can handwrite the answers in and add more pages are much better than forms that seem to be fillable. And I think we'll have those for you. But when I was assisting my daughter and had clients as well, those were the things that we had to prepare ourselves to try to anticipate, gosh, what do I have to ask? What does the law require? And now the school districts have done a really decent job, at least the ones I could find. There were other ones that just put the law, no more, no less. And those are not helpful, as you know and we know as lawyers. So I think maybe it's time to shift over to questions or chats, and because this is your rest of the hour is yours. So I apologize for all the legalese and throwing forms at you, but we're just trying to help you, as I needed help as a parent and as a lawyer.
Len, Nate, this is great information, and I would encourage folks to go to the Chapter 103 information on our website, because as you were touching everything, it was coming back to me about our checklist and how we unpacked a lot of information. So I think, again, it's not the end all, but I think it's a great start to be able to learn and know your rights as a family member. And so thank you very much for sharing that information. I've got a couple of questions, but before we get started, I want to hit something that I think I heard both of you speak to, is in this information, the thing that really stuck out to us as we were unpacking it for Mass Resource Center is the importance of being proactive, that this isn't to be reactionary all the time, that this is about being proactive. Okay, worst case scenario, you had to do a restraint and seclusion, but that's not the answer. So what happened? How can we figure it out so that you don't lead to that next time if all possible? So I think that's a really important piece to really empower family members to be able to go to those meetings, and educators. What can we do different? What can we do better? What can we unpack? What triggered it so that we can not do that again and help the child and the family member and the teacher to be more proactive. I just really think that's super important, that this is not about a solution. This is about trying to figure out the why behind it.